Yes, now you are
I'm
Mr. Dunn.
Mr. Dunn, on behalf of Ms. Karatysz, who's the appellant.
Yes.
Mr. Marvin, my learned friend, Queen's Counsel, appears on behalf of SGI Legal.
Yes.
Also in court is Mr. MacDonald, who is junior counsel in Belsner for the solicitors in that particular matter.
Junior counsel for the solicitors?
Yes.
Right.
And Mr. MacDonald is here on a watching brief,
down the middle.
but is happy to be called upon if it would assist.
Okay.
My lords, my lady, I was intending just to make some very brief submissions in respect to expand upon what was said in the letter that we sent into the court on behalf of Ms. Karatysz, obviously subject to any questions or interventions that the court may have. I should also say that I am junior counsel in Belsner for Miss Belsner as well. And my instructing solicitor is the instructing solicitor for Miss Belsner as well. So if I can assist the court in any respect in relation to any interplay between Belsner and this case.
And is it right that Waitmans are now on record for both solicitors in both appeals?
No, that isn't.
I don't know about Belsner.
But I thought
No.
Waitmans wrote a letter in relation to this matter. Am I wrong about that?
No, my lady, Waitmans instruct me in this matter, but I don't know if they're on the record for anyone in Belsner.
I see.
My lady, my understanding is that Waitmans are not on the record in Belsner. So my learned friend is acting in this particular case, but the SGI and the solicitors and Mr. Marvin are not instructed in Belsner.
And who's on the record for the solicitors in Belsner then?
In Belsner.
Direct
Oh
access.
yes,
Direct
yes,
instruction.
it is. Yes, it's
Right.
direct instruction. So it's the solicitors themselves. They also have cost lawyers acting for them, and they instruct Mr. MacDonald.
Right, so just remind me who's here in Belsner, at the back of the court for...
So
the
Mr. MacDonald
Mr. MacDonald.
is junior counsel for Cam Legal, who are the solicitors in Belsner.
And you are...
I'm instructed in the Karatysz case, so in this appeal as sole counsel.
Should we call it SGI? 'Cause
Yes,
it's so much
that may
easier.
be easier, SGI.
So,
So I'm instructed as sole counsel in SGI for Ms. Karatysz.
and you act for Miss Belsner.
And I'm junior counsel in the Belsner case with PJ Kirby QC.
Right. Can I just tell you why we're all here?
Of course.
I found the letters that were written not particularly helpful because they didn't address, as if ships passed in the night, they didn't address the question that had worried me in Belsner. Now, you were there, right?
Yes.
I'm sorry not to sort of have vivid memories, but it was your leader who made a greater impression. For some reason, you were probably hiding behind him. The concern I had is that grounds of appeal 7, 8 and 9, I think it was, in Belsner, were the substratum of the jurisdiction for the case. Right? So if it were right that section 74(3) did not apply to non-contentious business and therefore to the assessment of costs in this case, Belsner,
Yes.
then we needed to know that before we decided the other issues. So I sent everybody away, we sent everybody away, not including my lady, to think about that and argue it. And without deciding anything today, it seems to me at least arguable that section 74(3) does not apply to non-contentious business and that cases within the pre-action portal are non-contentious business, for good or ill.
Yes.
Right? And as also was made clear in Belsner, I think that this has serious consequences, maybe perfectly manageable, but serious consequences for the way business is conducted in personal injury cases in the pre-action space, which is mostly how personal injury cases are handled these days. So I didn't want to decide Cameron Belsner on the hoof without full argument about the jurisdictional questions, and I'm also interested in my capacity as chair of the Civil Justice Council in how these cases are managed and how they will be managed in a digital era. So I'm sort of intimately concerned, but very much out of the loop in which you and Mr. Marvin are very much in, of the way in which these cases are being litigated and all the decisions that are being reached at a lower level and the cost judges and what they're doing, and District Judge Bellamy and Mr. Justice Lemond and so on. Now, it therefore is, I think, slightly unfortunate that this case wasn't listed for one day the week after Cameron Belsner, and then your respective clients would be able to make sure you were in court listening to all the debate, and you would be able to argue the very interesting question about the size of this bill, understanding what the jurisdictional foundation for that was or not. Now, as I see it, the thing that your letters do not really deal with is we might be deciding the question of the size of that bill, if I can use that as a shorthand, on the basis that Section 70, subsection 9, applies to non-contentious business when it doesn't.
Yes.
Right? And I don't want to do that. I do not want to have a judgment of the court that says Section 79 means this or that.
My Lord, 74.3.
74.
Well, no, because in the case of
That's
79,
150.
that's
Yes.
your case,
Yes.
it's 79. Now, 74.3 is a slightly different question, because 74.3 is not in the same section of the
Yes.
Solicitors Act. And Section 74.3 could, in theory, apply to non-contentious business when Section 70, subsection 9 does not.
Yes. Yes.
Right? So my problem is I don't want to be deciding something under Section 79 which has been misapplied, and when the judge didn't tackle that question, although he said that the district judge had.
Yes.
Right, discuss.
Well, my Lord, that's very helpful.
And I'm pleased it is, because it makes little sense to me thus far.
The reason for writing the letter was that the appellant didn't want to be on the morning of this hearing and these points being made from the bench, because by then it would be too late. We would be all here
Exactly.
for the hearing. My Lord, Master of the Rolls has said that Belsner, quite rightly, is considering wider issues of how low-value portal personal injury cases are dealt with within this jurisdiction. And this case, and I'll come to why it's not directly on point, but this case is a part of that, because the question in this case is whether, when a solicitor sends in or delivers a statute bill which says it's for X, but there's a balance payable, what is the true amount of the bill for the 1/5 rule? And that is, if not unique, it's a fairly novel position which is only really required by solicitors in these low-value MOJ portal cases.
And why is that?
Well, the reason for that is that the success fee is capped at 25% of general damages. But what happens here, and it might assist.
Hang on, I don't think you finished that sentence. So my lady asks you, why is that? And you said the success fee is capped at 25%. What's that got to do with it?
Well, because what the solicitors do is that they charge the full base costs, which then allows them to calculate a success fee at 100% of those base costs, which produces a figure which is then capped by the 25%. And if my Lord, my Lady has the supplemental bundle, page 203, it's probably easier to actually see what the statute bill here says.
Sorry, you're going to have to give me a moment. So we're looking at We're looking at the supplementary bundle in this case.
Yes, in the Karatysz case, page 203.
And it's been corrected, has it?
It has, yes.
Good.
So this should now be a single page statute bill.
Page what?
203.
I've only got 187 pages in the supplemental bundle. And it finishes with the transcript of the proceedings before the DJ.
Right. There was an updated bundle sent in, I think, Monday.
Ah. That's why my lady's got it and I haven't.
My apologies, my lord.
It was sent in on Monday.
Yes, that's right.
Just hang on a second.
It is actually going down. I'll give it to you electronically. Page 203.
No, I've got it. Updated supplemental bundle. Thank you. Sorry, I need to get my papers in order because I don't have unlimited time to do admin.
My apologies, my lord, if that hasn't reached you.
No, it reached me, but I have been thinking about one or two other things. Right. And you want me to go to page 203,
Yeah,
which is the last page.
the last page. So there's 203 and 204, but 203 should be the single page statute bill, which one can see there are the basic charges. So that is the profit costs calculated on time spent multiplied by the hourly rate.
Mm-hmm.
Then the success fee, and this is what occurs in these cases. The success fee is 100% of that £1,717, but is then capped at 25% of damages.
But the 25%, the damages here were more than £1,000, weren't they?
They're 1,250.
Yes,
1,250, so there's no cap.
It's only in respect of so pain, suffering, loss of amenity, and it excludes future losses.
I see. So the 1,250 included less money for was less than £1,000 for pain and suffering.
It would have been calculated, yes, with excluding future pecuniary losses. Yes.
So what, it would be 4 times 260.
Yeah, exactly.
Right.
4 times 260. So it was capped.
Yes, it is capped, but if one considers, for example, if Miss Belsner resists the appeal in Belsner, then by virtue of 74.3, that 1717 could only be absent informed consent,
£500.
£500, and therefore you would then have a success fee which, in road traffic accidents, is not going to be 100%. It's going to be 12.5%, 20% at best. And one can see then that £500 would be the amount upon which the success fee is then calculated. So this is why we have, and I'm not going to get into submissions, and I hope I can put this as neatly as possible.
This is why it's relevant.
This is why it's relevant, and
This is why Belsner is relevant.
specifically because what
Even leaving aside my point.
yes,
I mean, you don't say my point is irrelevant.
no,
You say this could all be argued out on the assumption that there is jurisdiction, if I can use that
Yes.
catch-all.
yes,
But in addition, it is also relevant to know the outcome in Belsner because this will affect the way these bills are presented.
yes. And it's relevant for two. So there's two sort of main reasons. Firstly, the context point, and the context is that Karatysz is not to be seen in isolation. The situation in Karatysz with the bill is precisely the same situation as in Belsner. So in Belsner, you have a similar style bill which is calculated on the full profit costs. Then you have the success fee. Then you have the cap. And that is a part of the landscape of portal cases which my Lord Master of the Rolls is considering in Belsner. So it's important in terms of context for that reason to see it in its full context, because this is as much a part of the litigation landscape for MOJ portal cases as Belsner is.
Yes. So is there any reason why your case should not be tacked on the end of Belsner?
That is a suggestion I was going to respectfully make, that it could be. My only concern, my only concern in respect of Belsner is, and my Lord the Master of the Rolls will have seen the evidence that's come in from the Law Society as well.
I haven't. So,
Right.
I mean, I know it has, but I haven't. What does it say?
It's evidence in respect of contentious and non-contentious costs in 74.3, but it includes a lot of exhibits. There's a lot of evidence there. We have three.
What's it about?
It's about the history of the Law Society and whether the Law Society say they are contentious or non-contentious costs in terms of the portal.
What do the Law Society say?
The Law Society say that they are non-contentious costs.
And what do you say?
I say that the evidence that they've exhibited shows quite the opposite. But I'm putting a very partisan hat on when I say that.
No. I want you to put it back. I want to know what your case is.
No,
you say you are still saying contentious.
Yes.
And you'll be saying the same in Belsner.
Yes.
Which is the decision we have to make.
Yes.
And if you're right, then there's no jurisdictional issue at all. And my worry is wrong. I mean, I have to say that I think there is a strong case against you. Not because of the evidence I haven't seen from the Law Society, but simply because of the wording of the statute.
Yes.
I mean, you have some statutory construction hurdles to overcome, and you'd accept that.
Yes, and that's what we're tasked with doing. I accept that, but of course, when one considers the common sense definition of contentious,
well,
also,
then you're obviously right.
But also, which one considers, for example, what the Supreme Court have said in the Bott case.
Well, we didn't have Bott when we last
looked
at Belsner, but we do now. You say that helps you?
That does, because that includes consideration of whether proceedings, for example, one has to come back to, there's an interplay in Belsner as to the question of definition of proceedings and how that interplays with contentious or non-contentious costs.
And obviously, if you're right, then it sort of, I mean, I'm looking at it from a law reform perspective. If you're right, then law reform is less necessary.
Yeah, indeed. And that's part of Ms. Belsner's response to the Law Society's evidence. Firstly, that the evidence suggests that there has always been this understanding from the Law Society that their CFA was a contentious business agreement, subject to the line within it that says this is not a contentious business agreement, and that's why it's there. It's never been a non-contentious business agreement. And in fact, the Law Society have always cautioned solicitors never to use non-contentious business agreements because they're so tricky. But the position in Belsner is that if we're right about Belsner, and it does apply, then we say it doesn't make a difference at all to solicitors practicing in these matters. The only difference it makes is that they're required to provide informed consent if they want to recover more than the fixed
And
costs.
you think the time estimate in Belsner of 3 days is adequate?
That's my only slight concern.
Who's intervening in Belsner?
The Law Society. Just the Law Society. And
who are they represented by?
David Holland QC and Mr. Cohen, a junior counsel. But my understanding is that they have agreed that they will have an hour. I'll turn my back to Mr. MacDonald to see if that's correct. But my understanding is that they've agreed that they will have an hour of oral advocacy in Belsner. So their submissions shouldn't take up too much time.
So, I mean, 3 days sounds ample to me. So if we were to put this at the back of that, we would go on to the Friday.
Yes.
And that's feasible.
Particularly as this, my understanding is that we have a half day listed for this appeal.
Well, yes, I wouldn't. I mean, if it were coming on next Thursday, I would not. I would not limit it to half day. But I was going to say the estimate should be a day. But okay. Well, look, I think I get the point. let me hear from Mr. Marvin, who may have very strong views about this.
May I make two very, very short points in addition?
Yeah.
The first point is, from the appellant's perspective, there is no tactical advantage or disadvantage to either side in respect of whether this goes ahead next week or not.
Right.
It's genuinely not done for any tactical advantage because it won't make any...
When counsel says that, Mr. Dunn,
there
I'm
is one.
absolutely clear that
I
that's
wanted
not
to
right.
preempt anything that my learned friend might say.
And there's no prejudice and delay, self-evidently, on the facts of this case.
No.
Okay.
There's no prejudice in the delay. But also, the secondary point, in conversation with my Lord the Master of Rolls, I mentioned the context point, but there's also the practicalities point in that if Belsner decides that Section 74.3 does apply to these cases, then the practical effect of that will be that in these modest RTA portal cases, the vast majority of solicitors will be limited to charging fixed recoverable costs on a solicitor-client basis. Now, in Karatysz...
Without the success fee.
Well, with a success fee, but with a success fee calculated on the fixed recoverable costs rather than calculated on the profit costs,
Yes.
which are time times hours. Now, in those circumstances, if Karatysz is in a sense unfortunate, well, it's certainly unfortunate for Mr. Karatysz because the district judge found that Section 74.3 doesn't apply, and Mr. Justice Lavender at first appeal refused a respondent's notice on that point. So
Well, he refused the respondent's notice, didn't decide it, and then decided the case on the basis that it didn't apply, but if it didn't apply, then he had no business deciding it.
yes.
Right?
Yes, in essence, I mean, the arguments weren't put before him, and
No, but he was well aware of them from
Yes.
Belsner.
yes, of course.
He was
Indeed.
first instance involved.
Yeah.
Yes, he was first.
Yes, my lady, he was. Yes. But the situation will be this: if Ms. Karatysz's appeal will proceed on the basis of the bill as I have just highlighted to my lord and my lady. The questions regarding what the component parts of a bill have to be and what it has to say and what it means for the 1/5 rule, if that's decided on the basis of this bill and Belsner then goes to decide that Section 74.3 does apply, then the judgment in Karatysz will be very narrow in its scope indeed, because it will only really be dealing with this bill and very few other bills. It won't give any guidance to the profession or to consumers as to what will happen in cases where Section 74.3 bites. And that's because we're in an artificial situation in Karatysz whereby Belsner's going to decide whether Section 74.3 bites, but in Karatysz we're assuming that it doesn't.
Now, is that an argument in favour of parking SGI to await the outcome? I mean, beyond, are you there saying an alternative approach
Yes.
is to put this case off until judgment in Belsner is handed down?
My lady, yes, that would be my alternative proposition, because it's entirely a matter, obviously, for the court and the panel hearing Belsner, but obviously the Belsner decision will be reached by the panel, by the court, and that can feed into, if Karatysz is heard at the same time, that can feed into the Karatysz decision. But it can't be helpfully, in my submission, dealt with completely separately. It has to be dealt with as almost a single set of arguments.
I mean, how much difficulty, if any, is the decision below causing? Because having read or dipped into the transcripts and
Yes.
looked at the skeletons, it's clear that both of you recognise that most of these problems can be sorted or solved by much clearer drafting of a bill, clearer
Yes.
transparency. And surely solicitors on the ground in the real world now are all aware of these problems and are making sure that their statute bills are is that in practice that's not what's happening?
Not in my experience,
Right,
my
okay.
lady.
But it's the obvious solution, isn't it?
Yes, I mean but the reason one has to have this artificiality of these bills is because of the costs and funding regime in these portal cases. So there isn't many other situations in commercial circumstances, for example, where you would have a statute bill which says something but actually means
Yeah, but you could say
else.
the amount of this bill is,
Yes.
say total, on Mr Marvin's case, total is
Yes.
2731.90, but, red capitals, the amount of this bill is 157,150 because,
Yes. But if,
and that's all been paid.
but of course, the difficulty here is as well is that Miss Justice Lavender found on SGI Legal's submissions that the actual total is a third figure.
Oh, yeah,
the total's 1,550.
Yeah, well, it's the total of the last two
Yes.
figures.
Can I ask something related, but I think important? You said this case has been decided on the premise that section 74.3, was it 2?
3.
3, yeah. 74.3 does not apply to these cases,
Yes.
right? Which is what District Judge Bellamy decided, and Mr. Justice Lavender refused to consider on a respondent's notice.
Yes.
If section 74.3 does not apply, then surely section 79 does not apply, because that is the, and that's not right.
No, well, my understanding, and my learned friend may disagree, but my understanding is that section 70(9) applies to all.
And I was going to wait my turn, but the core of why I say this appeal does not need to wait is, as your lordship has appreciated, the assessment of the bill itself by the lower courts is not subject to the appeal. The only issue is what is the amount of the I consider to go back to the original bill as a starting point for the cost of the assessment. And it is common ground, and no one has ever suggested otherwise, that section 70 subsection 9 applies to all solicitors' bills, whether they are for contentious business or non-contentious business. So although the judge at first instance heard argument on 74.3, and Mr. Justice Lavender declined by way of a late respondent's notice to allow the respondent before him, the appellant before this court, to reopen that argument. That had nothing to do with this point. That was all about what the amount of the bill should be assessed at. No one has ever suggested that the application of section 70 subsection 9 depends on whether the bill is for contentious business or non-contentious business. It is common ground, and it has been hitherto. I'm told it still is, that section 70 subsection 9, which regulates the costs of the assessment, applies whether that assessment is of a bill for contentious business or whether it's an assessment of a bill for non-contentious business. So that's the core of my point.
But it was, in Mr. Justice Lavender, sorry to interrupt you, it was clear that this point was ground 3.
Yes.
And it was clear in his judgment that ground 3 only arises if you succeed on ground 1, as you did.
Yes, on the figures. If I had lost on that ground and we had been restricted to inter-parties costs, it wouldn't have mattered what the starting point was, because more than 20% would have come off, right. Whichever the. So yes,
but ground 1 wasn't the jurisdiction point.
No, ground 1 was whether or not we were restricted to inter-parties costs, and it was put before before the district judge on 2 bases by the claimant. The first was 74.3 applies and restricts you to inter-parties costs. They lost on that before the district judge and weren't allowed to raise it again before the judge.
I see.
The point on which they won before the district judge was a different point about whether costs should be presumed unreasonable under a different subsection of Rule 46.9, and they won on that before the district judge, but the judge on appeal reversed that and said the presumptions didn't work.
And that's not before us.
And none of that's before you. The assessment of the bill, right. I mean, at the risk of making a pejorative point, it's common ground that Ms. Karatysz is not owed any refund. The damages deduction stands. That's not in dispute. So the only question is what the amount of the bill was for the purposes of deciding the starting point to decide whether or not she got more than 20% off the bill.
But is it not the case, since Mr. Dunn has sort of sat down when you intervened without having finished his submission, I now understand that my misunderstanding, I mean, let me just make 2 points. I now understand that my misunderstanding about Section 70 was because I failed to spot the heading Remuneration General in the Solicitors Act above Section 67 and thought that the contentious business heading above Section 59, I think, was applicable to the entirety of the run of sections. The question on Section 74 is obviously different because Section 74 says it applies to contentious business.
Yes.
And therefore there is the question between you. That's the first point, and I now have rectified my misunderstanding. But
that doesn't arise on this
no,
appeal in
but
this case.
luckily I did call this hearing because, even if I did it maybe for the wrong reasons, because Mr. Dunn is now saying that SGI will be a very narrow decision if he wins in Belsner in establishing that that this type of business in the pre-action portal is actually to be regarded properly as contentious business. Do you agree?
No, it will make no difference to the scope of the decision in this case, whether he wins or loses on that point, because the only thing that's up for decision on this case, and my Lady Justice Carr is right, that actually, when you drill down, even if the appellant is right in this case, a solicitor could put the problem right by doing a bill that spelt out what might be said to be left implicit in this bill. But the only point that will be decided on this bill is how you approach the question of what is the amount of the bill. So the scope of this decision will be the same, whatever this court decides in Belsner about where the line is between contentious and non-contentious.
Is that right? Because won't it actually be relevant to consider the way bills should look? I mean, it's one thing to say, well, you can make it all very clear by spelling it all out. That we could say, I mean, the court could say, and it could then be sent out by way of advice to solicitors, read the Master of the Rolls or Lady Justice Carr's judgment, and you'll know how to do a bill. But wouldn't it be better to tell people how to do bills, knowing whether you're doing bills for contentious or non-contentious business, and whether caps and so on and CPR provisions apply? Because whilst I quite see that you could reach a sterile decision in a vacuum, knowing the nature of the argument over 3 days and all the stuff the Law Society wants to put in will inform the decision. I mean, first of all, you'd be better to have the same court, wouldn't you?
Well, any guidance the court might give about how a solicitor might present a bill, I would suggest is going to apply equally, whether it's contentious or non-contentious business. To take it specifically, whether it's a claim that, let's suppose that the line is between the portal, between issued and non-issued court proceedings. In this context, what a solicitor ought to do to make it transparent to a client how they have reached the final figure and what's payable will be the same, whether, for example, a claim concludes at stage 1 of a portal where there aren't issued proceedings, or at stage 3 where there are issued proceedings. So, respectfully, I don't see that any guidance the court might give will impact on that. But still less will it impact on the question of what is the amount of this bill.
Well, I see that. I don't think anybody's suggesting it impacts on the amount of this bill.
I mean, and of course, your lordship will want to manage all this coherently, and I do.
No, but I mean, it does
that,
impact on this bill, because if it's affected by Section 74(3), this bill's too big.
Well, if it was open to them to appeal the amount of the assessment of this bill, that might be relevant. But they're not appealing that. So
no.
I mean,
it might be relevant, but I mean, it's all very well to say it's got nothing to do with it because they haven't appealed it. It is. We want to give a judgment that is coherent, and it would not be a coherent judgment if we said this bill's absolutely fine, but actually we've just given a judgment which says it's not.
But that goes to, but whether or not this bill is fine, in other words, whether or not this bill ought to have been reduced, is separate from the question of what is this. The question for the court in this appeal is what is this bill at page 203 for? What is the amount of this bill?
No, I understand all that. I mean, the point I'm really making is not that I disagree with you that in theory the thing can be decided in a vacuum, but if Section 74(3) does apply, contrary to the assumption and decision of District Judge Bellamy and the absence of decision of Mr. Justice Lavender in this case, then the argument about how bills should look and what they should say and how they should refer to capping and how they should refer to Section 74(3), if at all, will not have been had. Whereas it could be had, and very easily. I mean, what is the practical difficulty in tacking Belsner on to day 4, and tacking this onto Belsner on day 4?
So I was just looking, as your lordship, is that 14th of, the 15th of...
Well, I think, I don't know what day the 14th of July is.
It's the Friday of that week.
The Friday of that week. I mean, if I am allowed to indulge in a personal point, I do have something else in my diary that day. I mean, I appreciate that that's not going to be this court's greatest concern.
I know, but it's the same solicitors.
No, my lord.
Oh, no, we decided they were.
I was wrong.
But I mean, if I may, I mean, if this point has been a point worth raising, it's been worth, with respect to my learned friend, something. I understand why they would have assumed that the argument of Belsner would have concluded in February. But if it had been a point to flag to the court, they've had months to do that, and this appeal is listed for next week, and it is potentially, with respect, it is potentially disruptive to the parties.
Okay, now next week is a week of rail strikes. Does that affect anybody?
It doesn't affect. It won't affect me, but
It will affect me and my instructing solicitor. It's we're listed, my lord. We're listed for Thursday,
Which is a day of strike.
So there's, for example, I read today there's no trains going from my station at all on Thursday morning. So yes, it potentially does disrupt.
You see, what I'm worried about is we get an application on Monday next week when people realise the strike is going ahead to adjourn the case anyway.
well, my lord, yes. I mean, I don't think my learned friend has gone so far. It's not been suggested to your lordship thus far that the strike is going to prevent.
No, but then then the application is further made to make it remote, and that's a very almost irresistible application when counsel says I can't get there because I can't get there, and also we have staff problems in court potentially. So what I don't want to do is to bang my fist and say we're going to hear this case come hell or high water next week, and then find we can't. That's all.
Well, my lord, I understand that.
And I do want this case to be in person.
Yes, it's clearly much preferable, and I wouldn't disagree with that.
Okay. So
well,
you say, well, it doesn't matter. We can decide it. It's really the same issue. It's the way the bill should look, and that is not affected by 74(3)
and 79 applies whether this is contagious.
79 applies anyway, which I now realise is correct. And there we are.
My lord.
As you say, it may not be a particularly material consideration, but just out of interest, on the 15th of July, is it a court commitment you have, or is it something that could be moved?
It's a court. I mean, it might be something that could be moved. It's not the Court of Appeal, but it is a court commitment.
Well, I remember a rule when I was at the bar that the Court of Appeal takes precedence.
No, I mean, I appreciate that my personal convenience is not the court's, I only trouble the court with it because this is in effect a very last-minute application.
We'd very much like to have you there, Mr. Martin.
But it might be possible to move it, but I mean, but it might not.
It might not. No. Okay, well, we'll take that into account. Mr. Dunn, do you want to say anything else?
My lord, I only want to say one short submission, which is essentially, I'm not in disagreement with my learned friend in the sense of this particular case. If we look at it as a very discrete case which may not apply to any others, then yes, we could hear it. But my learned friend said, quite rightly, that it wouldn't have mattered in this case whether Belsner succeeds or not because of the artificiality of how this case has progressed, so we don't have 74.3 as part of this case. But what will happen then, and this is what my Lord Master of the Rolls makes this point, what will happen then is we will have a judgment on this bill, which is not indicative of bills in this arena of litigation at all. And all one needs to think about in my submission is this. If section 74.3 applies and the appeal in Belsner is resisted, this bill becomes completely different, and the 1/5 rule falls away, because even in this case, the 1/5 rule falls away. It doesn't matter anymore, because that £1,717 becomes £500. And if there's going to be guidance given, because all that will happen is the disputes about the nature of bills and the 1/5 rule, if guidance is going to be given, it really needs to be given post-Belsner. Otherwise, it's of benefit to SGI Legal and Ms. Karatysz in this case, but it's of no benefit to anybody else.
Right.
And if this court is, as they are, looking at this in a wide-ranging bird's eye view, taking a bird's eye view approach of this in the context of online courts, in the context of the future of litigation, then it's right in my submission that this case is dealt with as part of that consideration.
Right, I've got that point.
Thank
The only thing is, anything I might say is assuming that the Friday is available anyway. It may not be, because there are other members of the court and I don't know their diaries. So if we were to adjourn it, we would very likely adjourn it to another day, possibly the Friday after Belsner, but anyway, another day this term after Belsner with the same constitution, or at least 2 of the 3 constitution in Belsner. That's what I'm having in mind. Mr. Marvin, do you have any thoughts about that? If that were the...
Well, I've made my submissions urging the court
You're
not
not happy with the Friday, but...
I mean, if it has to be adjourned, I wonder if it would be possible to feed in available dates if I can't get the Friday moved. But
well, that's what I was going to do. I was going to say that it should be fixed. But let's consider whether we're going to adjourn it at all, and then we can have another discussion if we do. So we'll just rise for a couple of minutes.
I forgot to change it to 2 judges. See where on the side it's got 3, 2, 1, 1, 2, 3. Oh, could you run out and get counsel? I'm sorry, sorry. I apologise. All rise.
This is this is a hearing convened by the court to consider whether it's appropriate to adjourn the appeal in Karatysz versus SGI Legal from the date that has previously been fixed for Thursday, the 23rd of June, which is now 8 days away. I do not intend in this very short judgment to go into the detail of the issues that will be debated at the hearing. In short, however, Mr. Dunn, counsel for the client, submits that it would be convenient and helpful for the court to hear argument in this case after the argument and perhaps the decision in another case called Carr and Belsner, which is fixed to be heard by this court for 3 days on the 14th of July. The Court of Appeal has already decided that there should be an overlap between the constitutions hearing this case and Carr and Belsner. The reason for that is that there are related issues. What prompted me to convene this hearing was that the question of whether Section 74.3 of the Solicitors Act 1974 applies to cases within the pre-action portal for Road Traffic Act claims arises, at least in principle, in both cases. In this case, the district judge decided that Section 74.3 did not apply. Mr. Justice Lavender refused to allow a late respondent's notice in order to raise the point before him, so decided the case on the basis that it did not apply. But in Belsner, the client is arguing that it does apply. In other words, that cases within the pre-action portal for Road Traffic Act cases are cases that should be regarded as contentious rather than non-contentious business under the Solicitors Act 1974. The solicitors, represented by Mr. Marvin, Queen's Counsel, before me today, argue that the question to be decided in this case under Section 70, subsection 9 of the Solicitors Act 1974 is the same, whatever the answer to the Section 74, subsection 3 question. Technically, he is right. However, as Mr. Dunn has submitted, there might be a different approach to the way bills are prepared or ought to be prepared in the event that the cap provided for in Section 74.3, limiting solicitor and own client costs to those recovered on a party basis applies. In those circumstances, it seems to me that the expedient course is to adjourn the argument in this case until after the argument in Carr and Belsner. Mr. Marvin has indicated that he has availability difficulties on Friday, the 17th of July, which would be the day immediately following the 3 days of argument in Belsner. I do not think that today we can decide when precisely the argument in this case should take place. It should, however, take place as soon as possible after Carr and Belsner, hopefully on that Friday, if diaries can be so arranged. Otherwise, as soon as possible thereafter. Again, it would be very desirable if it could be heard before the end of term, so that the judgments in Carr and Belsner and in this case can be prepared at the same time. It would also be helpful if the constitution of the courts overlapped, but again, it is not absolutely necessary that there is a complete coincidence in constitutions, and there may not be. So for those reasons, I would be in favour of adjourning SGI from next week. I understand, as Mr. Marvin has submitted, that this is a slightly late application, but the issues in Cam and Belsner have been developing since the 2 days of argument in February 2022, when I adjourned that case for further skeleton arguments and evidence to be provided. So that's what I would do.
And I agree. It's the 15th, not the 17th of July.
So what's the first day? So the
Monday's
Tuesday
the
is the
12th.
right. So when I said the 15th of July, I should have said the 12th of July. It's Tuesday the 12th of July that the argument starts in Cam and Belsner, and it's Friday the 17th.
15th.
Friday the 15th of July, which is the date on which Mr. Marvin may or may not be available, and it's the date on which ideally this case will be heard. I will ask the listing office to deal with listing urgently, but maybe you can ask your clerks to liaise with the listing office so that that is done as soon as possible. Yes. Thank you very, very
Mr.
much.
McDonald wants to say something.
Mr. McDonald, yes.
First, I apologise for my attire. I was only a watching brief.
Don't worry, last night we had a case in which counsel for the Secretary of State appeared in a T-shirt and jeans.
Well, I'm glad I came. So I only wanted to flag that there's a possibility that if this is tagged onto the end of Belsner, then we, i.e. the solicitors in Belsner, so Cam Legal, would wish to make submissions on the section 70 point, so the 1/5 rule point, because it affects us in Belsner, although it's not before the Court of Appeal.
Well, what a surprise, Mr. McDonald. That seems to demonstrate
We were right.
that the decision of the court was right. Thank you for that. I don't see any reason why that can't be the case. You could ask your clerk to liaise with the clerks for counsel in SGI to make sure that that is accommodated. I don't suppose it'd be lengthy submissions. And obviously we don't want to have counsel appearing for 3 days who don't need to appear, or vice versa, but I'm sure that sensible arrangements can be made between the parties to ensure that we hear helpful argument on all points and can then go away and decide these very interesting questions at our leisure. Thank you.
All rise.